Bill 1240, testifying as a parent and on behalf of the MCC PTA. And I would like to begin by thanking Delegate Kaiser so very much for this bill, for hearing parents' concerns, for addressing them in amendments, and for providing what I think is a very strong and helpful bill which will promote consistency across the state. I say that as a parent. My child is a senior. I'm not going to benefit. I'm sorry, he's in high school. I'm not here because this bill will benefit me. I'm here on behalf of other students. Burden of proof is about fairness and due process. It's about increasing collaboration in IEP meetings, as Delegate Kaiser said, not just in Georgia, but New York, New Jersey. We've seen fewer hearings once they shifted the burden of proof back to the school districts. And what is worth noting, I think, is that in New York, the New York State Teachers Union supported shifting the burden of proof to the school district because they had the burden of proof before Schaefer v. Wiest. New York was familiar with what it meant to have the burden of proof. They knew it was not this big, scary, onerous thing. They knew that it was a matter of fairness. So when they had the opportunity to put the burden of proof on parents because of the Supreme Court decision, their reaction was to work with parents and pass legislation that took back the burden of proof on the school districts. And of course, they're not the only state that has done that. Right now, we see inconsistent collaboration because the deck is stacked so high against parents that schools know they'll win in due process even if they aren't providing FAPE. And that's what undermines the collaboration. If to give you a couple of examples, and again, I've had some wonderful services for my son, but I was once told I had to accept a change in my child's placement sight unseen. When we objected and filed for due process, we were denied access to the placement and important documents like curriculum materials. 2 years later, I learned that his school was not providing a major service in his IEP. However, instead of rectifying the situation, the school responded by significantly cutting his service in order to comply in the future and told us that if you don't like it, you can sue. You have due process. So it's dangled before parents not as an opportunity to resolve differences, but often as just, I don't mean to say a threat, but, a stark reality that's not helpful. But this isn't just about the stories that you've heard in the hearings relating to this issues. It's about the overwhelming disadvantages that parents face. Schools have full access to the experts, the records, the instructional materials, and placements. They know how similarly situated children have fared at those placements. Parents do not. In Maryland, here in the Fourth Circuit, schools have the added legal advantage that the ALJ begins its hearings giving deference to school district expert witnesses over that of parents. That doesn't mean the parents always lose, but if you have a school psychologist who's met with a child a couple of hours and a parent and a therapist who have a regular relationship, the ALJ starts off by giving deference to the school district witness. So they have all of these advantages, and then the parents have the burden of proof. Parents also have to ask staff to testify against their supervisors. And then, of course, we have pro se parents who can't afford an attorney, who aren't attorneys, and they have to try to litigate these cases against a school district lawyer. And what sometimes happens when a parent is pro se, and I can supply the case example of this, that the parent doesn't understand the rules, fails to provide the IEP in advance to the school district has moved against the parent, said we can't consider the IEP, you failed to serve it on us 5 days in advance. The ALJ said that's right. We will not consider the IEP, and then the school district moved and won the case without putting on a shred of evidence because the parent had the burden of proof. And the only way to make sure we never have decisions made based upon where the school district hasn't had to provide any evidence is to put the burden of proof on the school district. I will close very soon. I do want to mention that we do have a recent Supreme Court decision in Andrew. And in the Andrew case, IEPs are now provided to require more than a de minimis benefit. However, while some may argue that this warrants holding back on this bill on burden of proof. It doesn't. In fact, quite the contrary. If we want to keep the status quo, if we keep the status quo, burden of proof, due process remains broken. It's too hard for parents. This accountability mechanism is broken, and parents will remain unable to hold schools accountable when they fail to provide FAPE, and thus this Andrew decision will fail to help the very students it's intended to help. Thank you. Okay.
We haven't started using the clock, but we will. We want people to keep it. We have about 20 more bills. Before we go on, just a clarification. The item you cited of an ALJ considering the school expert as significant, greater weight, is that in code or is that in Court of Appeals orders?
It's a Fourth Circuit decision.
Okay.
And I'm happy to forward it to you if you like. I can find it.
Great, thank you. Next, again, whomever. You can just move that.
Good afternoon. My name is Amathan Cannon. I'm here to request your support for the bill 1240. My older son has Down syndrome and attends a Montgomery County public school. I've been involved in special ed for 13 years as a parent, as well as a special ed advisory committee co-chair in Montgomery County. Based on my experiences, I strongly believe that parents like us are at an unfair position in our advocacy for our kids. My wife and I are educated professionals. Too often, we have left IEP meetings for my son with jargons or programs that are unfamiliar to us. I work with many parents who have fewer resources. How can the individual families match the professional, legal, financial, and human resources available to the school system? It is completely unfair. I'm here to ask you to help the special education families by supporting HB 1240. We need the burden of proof to be placed on the schools where it naturally belongs, and not on us, parents. The best teachers and therapists my son had in the past 13 years always shared the data behind their opinions and recommendations. When a placement decision is recommended by the school team, the parents want to just see the data behind the recommendation. Families will not be able to find the resources available to the school system to handle the burden of proof on them, and can never match the resources available to the school system, as everyone can see. The burden of proof on school should not create more work for the staff. That was one of the contending argument, I think. The recommendations by the team should have been preceded by the data collection. It's just a matter of taking notes and recording data, that's all. And the staff are doing it already. So placing the burden of proof on schools will make the teachers feel better, actually, knowing they have the data to support the decision rather than being called to testify later in the game and having to match their supervisor's recommendation. Placing burden of proof on schools should improve the collaborative effort between the families and schools, increasing the communication and sharing of data between the parents and the schools before placement decisions are made. Please think about children like my son, and I request you to support the bill. Thank you.